This article, in need of care and treatment, means that a person has a mental illness for which inpatient care and treatment in a hospital is appropriate. In need of care and treatment means that a person has a mental illness for which inpatient care and treatment in a hospital is appropriate. 2. In need of involuntary care and treatment means that a person has a mental illness for which care and treatment as a patient in a hospital is essential to such person's welfare and whose judgment is so impaired that he is unable to understand the need for such care and treatment. In need of involuntary care and treatment means that a person has a mental illness for which care and treatment as a patient in a hospital is essential to such person's welfare and whose judgment is so impaired that he is unable to understand the need for such care and treatment. 3. Likelihood to result in serious harm or likely to result in serious harm means 1. A substantial risk of physical harm to the person as manifested by threats of or attempts at suicide or serious bodily harm or other conduct demonstrating that the person is dangerous to himself or herself. Or 2. A substantial risk of physical harm to other person as manifested by homicidal or other violent behavior for which others are placed in reasonable fear of serious physical harm. 4. Need for retention means that a person who has been admitted to a hospital pursuant to this article is in need of involuntary care and treatment in a hospital for a further period. 4. Need for retention means that a person who has been admitted to a hospital pursuant to this article is in need of involuntary care and treatment in a hospital for a further period. 5. Record of a patient shall consist of 1. Admissions. 2. Transfer or retention papers and orders is 3. And 4. Accompanying data required by this article and by the regulation of the Commission. So the record of a patient shall consist of 4 things, and it is admission, 2. Transfer or retention papers, 3. Orders, and 4. Accompanying data. 6. Director of Community Services means the Director of Community Services for the mentally disabled appointed pursuant to Article 41 of this chapter. 8. Qualified psychiatrist means a physician licensed to practice medicine in New York State who 1. is a diplomat of the American Board of Psychiatry and Neurology or is eligible to be certified by that board, or B. is certified by the American Osteopathic Board of Neurology and Psychiatry or is eligible to be certified by the board. Mental Hygiene Law, Article 9.05, examining physicians and medical certificates. A. A person is disqualified. A person is disqualified from acting as an examining physician in the following cases. 1. He's a relative of the person applying for the admission or of the person alleged to be mentally ill. 2. If he is a manager, trustee, visitor, proprietor, officer, director, or stockholder of the hospital in which the patient is hospitalized, or to which it is proposed to admit such person, except as otherwise provided in this chapter, or if he has any pecuniary interest. We can look that up in the dictionary. I don't even know what it means. Directly or indirectly in such hospital. 3. He is on the staff of a proprietary facility to which it is proposed to admit such person. B. A certificate, as required by this article, must show that 1. The person is mentally ill, and 2. Shall be based on an examination of the person alleged to be mentally ill made within 10 days prior to the date of admission. Again, a certificate, as required by this article, must show that the person is mentally ill and shall be based on an examination of the person alleged to be mentally ill made within 10 days prior to the date of the admission. 10 days prior to the date of the admission. The date of the certificate shall be the date of such examination. The date of the certificate shall be the date of such examination. All certificates shall contain the facts and circumstances upon which the judgment of the physicians is based, and shall show that the condition of the person examined is such that he needs involuntary care and treatment in a hospital, and such other information as the commissioner may be regulation require. Okay. Mental Hygiene Law, Article 9.07, notice to all patients of their rights of the availability of the mental hygiene legal services. I guess this is like legal aid for mentally ill people. I'm guessing. Okay. A. Immediately upon the admission of any patient to a hospital or upon his conversion to a different status, the director shall inform the patient in writing of his status, including the section of this chapter under which he is hospitalized, and of his right under this article, including the availability of the mental hygiene legal services. At any time thereafter, upon the request of the patient or of anyone on the patient's behalf, the patient shall be permitted to communicate with the mental hygiene legal services and avail himself of the facilities thereof. B. The director of every hospital shall post copies of a notice in a form and manner to be determined by the commissioner at places throughout the hospital where such notice will be conspicuous and visible to all patients, stating the following. 1. The availability of mental hygiene legal services. 2. A general statement of the rights of patients under the various admission or retention provision of this article. And 3. The right of the patient to communicate with the director, the board of visitors, the commissioner of mental health, and the mental hygiene legal services. Mental Hygiene Law, Article 9.09, notices to mental hygiene legal services concerning minors. When any person under the age of 18 years is admitted to or is converted from one admission status to another in any hospital, written notice of such admission or conversion shall be given to the mental hygiene legal service within 3 days. Within 3 days. Thereafter, and such notice shall specify the age of and admission procedure applicable to such person. No such person shall be transferred to any other hospital without the prior consent of such person and the prior written consent of his parent or legal guardian, unless 3 days prior written notice of such proposed transfer is given to the mental hygiene legal service, and an opportunity is afforded to the service to see such person and to review the proposed transfer. Immediately upon release or transfer, immediately upon release or transfer of any such person, the director of the hospital shall give the mental hygiene legal service written notice thereafter. Again, notice to mental hygiene legal service concerning minors. Any person under the age of 18 admitted shall be given to the mental hygiene legal service within 3 days written notice of such admission. Again, under 18 admission status or is admitted shall be given to the mental hygiene legal service within 3 days. Okay? No such person shall be transferred to any other hospital without the prior consent of such person and the prior written consent of his parent or legal guardian, unless 3 days prior written notice. Written notice, 3 days. Admission, 3 days. when any person under the age of 18 years is admitted to or is converted from one admission status to another in any hospital, written notice of such admission or conversion shall be given to the mental hygiene legal service within 3 days thereafter, and such notice shall specify the age of and admission procedure applicable to such person. No such person shall be transferred to any other hospital without the prior consent of such person and the prior written consent of his parent or legal guardian, unless 3 days prior written notice of such proposed transfer is given to the mental hygiene legal service and an opportunity is afforded to the service to see such person and to review the proposed transfer. Immediately upon release or transfer, immediately upon release or transfer of any such person, the director of the hospital shall give the mental hygiene legal service written notice thereafter. Again, notice to mental hygiene legal service concerning minors. Any person under the age of 18 admitted shall be given to the mental hygiene legal service within 3 days written notice of such admission. Again, under 18 admission status or is admitted shall be given to the mental hygiene legal service within 3 days. Okay? No such person shall be transferred to any other hospital without the prior consent of such person and the prior written consent of his parent or legal guardian unless 3 days prior written notice. Written notice, 3 days. Admission, 3 days. Right. This is mental hygiene, Article 9, and this is 9.39. I skipped quite a few things for now just because it was talking about Article 9.39 and 940. So I'm going to do 9.39 first and then go back because there was, when I get notes, because there was just too much on it. Okay, so 9.39 is an emergency admissions for immediate observation, care, and treatment. A, the director of any hospital maintaining adequate staff and facilities for the observation, examination, care, and treatment of persons alleged to be mentally ill and approved by the commissioner to receive and retain patients pursuant to the section may receive and retain as a patient for a period of 15 days any person alleged to have a mental illness for which immediate observation, care, and treatment in a hospital is appropriate and which is likely to result in serious harm to himself or others. Likelihood to result in serious harm, as used in this article, shall mean 1. A substantial risk of physical harm to himself as manifested by threats of or attempts at suicide or serious bodily harm or other conduct demonstrating that he is a danger to himself. And yes, it says himself, not herself. Just himself. Or 2, a substantial risk of physical harm to other persons as manifested by homicidal or other violent behavior by which others are placed in reasonable fear of serious physical harm. Okay. So that's what it means. So again, likelihood to result in serious harm shall mean a substantial risk to himself by means of threats or attempts at suicide or serious bodily harm or other conduct demonstrating that he is a danger to himself, or substantial risk of physical harm to others by homicidal or other violent behavior by which others are placed in reasonable fear of serious physical harm. Now, the director shall cause to be entered upon the hospital records the name of the person or persons, if any, who have brought such person to the hospital. So that's a little bit different. And 2, the details of the circumstance leading to the hospitalization of such person. So that's going to be in the hospital records. Who took the person to the hospital and the circumstances and details of why they're there. So I guess this is kind of, it's kind of like, oh, whatever. Okay. The director shall admit such person pursuant to the provisions of this section only if a staff physician of the hospital, upon examination of such person, finds that such person qualifies under the requirements of this section. So they have to be looked at by one of those doctors first to see if they fit the requirements to go into like a psychiatric hospital. Such person shall not be retained for a period of more than 48 hours unless within such period such finding is confirmed after examination by another physician who shall be a member of the psychiatric staff of the hospital. Such person shall be served at the time of admission with written notice of his status and rights as a patient under this section. Such notice shall contain, so this is what the notice is going to contain to the person. 1, the patient's name. And 2, they will be given to the mental hygiene legal services and personally or by mail to such person or persons not to exceed 3 in number as may be designated in writing to receive such notice by the person alleged to be mentally ill. If at any time after admission, what time is it? The patient, any relative, friend, or the mental hygiene legal services gives notice to the director in writing of request for court hearing on the question of need for immediate observation, care, and treatment, a hearing shall be held as herein provided as soon as practicable, but in any event not more than 5 days. If at any time after admission, the patient, any relative, friend, or the mental hygiene legal services gives notice to the director in writing of request for a court hearing on the question of need for immediate observation, care, and treatment. Again, this is a request for a hearing to question the need for immediate observation, care, and treatment. A hearing shall be held as herein provided as soon as practicable, but in any event not more than 5 days after such request is received, except that the commencement of such hearing may be adjourned at the request of the patient. It shall be the duty of the director, upon receiving notice of such request for hearing, to forward forthwith a copy of the notice with a record of the patient, and here's where this hearing is going to happen, to the Supreme Court or county court in the county where such hospital is located. A copy of such notice and record shall also be given to the mental hygiene legal service. The court which receives such notice, the court which is going to be Supreme or County Court, which receives such notice, shall fix the date of such hearing and cause the patient or other person requesting the hearing, the director, the mental hygiene services, and such other person as the court may determine to be advised of such date. Okay, so the court receives the notice, and they're going to fix a date, and they're going to tell these people, 1, the patient or other person requesting the hearing, 2, the director, 3, the mental hygiene legal service, and any other person as the court may determine to be advised of such date. Upon such date, or upon such other date to which the proceeding may be adjourned, the court shall hear testimony and examine the person alleged to be mentally ill. If it to be deemed advisable in or out of court, and shall render a decision in writing that there is reasonable cause to believe, again, that there is reasonable cause to believe that the patient has a mental illness for which immediate inpatient care and treatment in a hospital is appropriate, and which is likely to result in serious harm to himself or others. If it be determined that there is such reasonable cause, the court shall forthwith issue an order authorizing the retention of such patient for any such purpose or purposes in the hospital for a period not to exceed 15 days from the date of admission. The order entered shall not be deemed to be an adjudication. It shall not be deemed to be an adjudication, just like an ACOT, not an adjudication, but only a determination. This is different. Only a determination that there is reasonable cause to retain the patient for the purposes of this section. Mental Hygiene Law, Article 911, Patients' Records. Except as to informal patients and patients admitted pursuant to Sections 939 or 940, the director of a hospital shall, within 5 days excluding Sunday and holidays, 5 days excluding Sunday and holidays, only Sunday and holidays, after the admission of any patient, forward to the Mental Hygiene Legal Service a record of such patient, and shall is simultaneously forward to the department such information from the record as the commissioner by regulation shall require. Such information from the record in the department shall be accessible only in the manner set forth in section 33.13. A hearing demanded by the director to involuntarily retain a patient who initially entered the facility voluntarily must be set by the court, Supreme or County Court where the hospital is located, not later than 3 days from the date such notice has been received by the court. The notice shall be fixed by the court, shall be at a time not later than 3 days from the date such notice has been received by the court. If it is determined by the court that the patient is mentally ill and in need of retention for involuntary care and treatment in the hospital, the court shall forthwith issue an order authorizing the retention of such patient for care and treatment in the hospital, or if requested by the patient, his guardian or committee, in such other public, non-public hospital as may be within the financial means of the patient for a period not exceeding 60 days from the date of such order. What the? Okay, 913, voluntary admissions. The director of any hospital may receive as a voluntary patient any suitable person in need of care and treatment who voluntarily makes written application thereof. If the person is under 16, so that's 0 to 15 years of age, the person may be received as a voluntary patient only on the application of 1, the parent, 2, the legal guardian, 3, next of kin, 4, social service official or authorized agency with care and custody of the person as per Social Services Law 384A. 5, the director of the Division for Youth. And 6, a person or entity having custody of the person pursuant to an order issued pursuant to Section 756 or 1055 of the Family Court Act. If the person is over 16 and under 18, which to me seems like it would just be 17, but I don't know why they wouldn't just write 17 then. Okay, the director may, in his discretion, admit such person either as a voluntary patient on his own application or on the application of that list that I had before. 1, the parent, 2, the legal guardian, 3, the next of kin, 4, social service official or authorized agency with care and custody, 5, the director of the Division for Youth, or 6, a person or entity having custody of the person. If such voluntary patient gives notice in writing to the director of the patient's desire to leave the hospital, the director shall promptly release the patient. However, If there are reasonable grounds for belief that the patient may be in need of involuntary care and treatment, the director may retain the patient for a period not to exceed 72 hours from the receipt of the notice, and shall either release the patient or apply to the Supreme Court or the county court in the county where the hospital is located for an order authorizing the involuntary retention of such patient. The application and proceedings shall be in the manner prescribed in this article, except that notice of such application shall be served forthwith, and if a hearing be demanded, the date for a hearing to be fixed by the court shall be at a time not later than 3 days from the date such notice has been received by the court. If it be determined by the court that the patient is mentally ill and in need of retention for involuntary care and treatment in the hospital, the court shall forthwith issue an order authorizing the retention of such patient for care and treatment in the hospital, or, if requested by the patient, his guardian or committee, in such other non-public hospital as may be within the financial means of the patient for a period not exceeding 60 days from the date of such order. Further application for retention of the patient for periods not exceeding 6 months, 1 year, and 2-year periods thereafter, respectively, may be made in accordance with the provisions of this article. In the case of a patient under 18 years of age, such notice requesting release of the patient may be given by the patient, by the person who made application for his admission, by a person of equal or closer relationship, or by the mental hygiene legal service. Okay, and then it says, if such notice be given by any other person, the director may, in his discretion, refuse to discharge the patient, and in event of such refusal, such other person or the mental hygiene legal service may apply to the Supreme Court or to a county court for the release of the patient. 915 says, such person may be admitted as a patient without making formal or written application thereof, and any such patient shall be free to leave such hospital at any time after such admission. So that's only with involuntary admissions. Now we have voluntary and informal admissions, the suitability of it. In order for a person to be suitable for admission to a hospital as a voluntary or informal patient, like, why do we need to know this stuff? Why do we need to know this? Okay. All right, let me go back to this. All right. In order for a person to be suitable for admission to a hospital as a voluntary or informal patient, or for conversion to such status, he must be notified of and have the ability to understand the following. 1, that the hospital to which he is requesting admission is a hospital for the mentally ill. 2, that he is making an application for admission. And 3, the nature of the voluntary or informal status as the case may be, and the provision governing release or conversion to involuntary status. Okay? And B, the department shall have the power. Ooh, that's a good question. The department shall have the power to examine the patients admitted pursuant to this section and determine if they belong to the voluntary or informal class. Any failure to conform to the requirements of this section shall be considered a sufficient cause for revocation. 919, voluntary and informal admissions, notices. The director shall cause all patients admitted as voluntary or informal patients to be informed once during each 120 days of hospitalization of their status and rights. That's once within 120 days. Once within 120 days. Okay. There was another 120 days. The director shall cause all patients admitted as voluntary or informal patients to be informed once during each 120 days of hospitalization of their status and rights, including their right to avail themselves of the facilities of the mental hygiene legal services. At the time of such periodic notification, the written consent of a patient to his continued stay as a voluntary or informal patient shall be attained, and a copy shall be given to the mental hygiene legal services. 921. It shall be the duty of all state and local officers. Man. Mental Hygiene Law 921, voluntary and informal admissions, the encouragement of. So this is when they're trying to encourage them to stay in. Okay. A, it shall be the duty of all state and local officers having duties to perform relating to the mentally ill to encourage any person suitable and in need of care and treatment for mental illness to apply for admission as a voluntary or informal patient. No requirement shall be made by rule regulation. Applying for admission shall have the legal capacity to contract. What? Does that even make sense? No, because I didn't read the whole sentence. Oh, jeez. Going back. Talking to myself because I'm crazy, because I'm talking about mentally ill people. It's making me crazy. Okay. No requirement shall be made by rule, regulation, or otherwise as a condition to admission or retention that any person applying for admission shall have the legal capacity to contract. And I still don't even understand what I read after reading it, so I don't know why I went back. C, a person requesting admission to a hospital who is suitable for admission on a voluntary or informal status shall be admitted only on such a voluntary or informal status. The hospital shall have the discretion to admit the person on either such status, except that if the person specifically requests admission on an informal status and is suitable thereof, he shall be admitted only on such informal status. I can't even see that ending being in a question, but there it is. Now we have voluntary and informal admissions conversion 2. Nothing contained in this article shall be construed to prohibit any director from converting, as shall be his duty to convert, the admission of any involuntary patient suitable and willing to apply, therefore, to a voluntary status. The mental hygiene legal service shall be given notice of every conversion from an involuntary status to a voluntary status. B, any patient converted from an involuntary status to a voluntary status shall have the right to a judicial hearing before the Supreme Court or a county court on the questions of his suitability for such conversions, on his willingness to be so converted. So, obviously, as I've been reading this, there is a theme here with hearings, orders being needed, motions. Everything is going to be done with this article in Supreme Court or County Court, where the hospital is, where the hospital is located. Formal admissions. Review of the status. No voluntary or informal patient, whether admitted on such status or converted thereto, shall be continued in such status for a period beyond 12 months from the date of commencement of such status, or beyond 12 months from the effective date of this statute, whichever is later, unless the suitability of such patient to remain in such status and his willingness to so remain have been reviewed. The director shall review the suitability of such patient to remain in such status. And I'm just going down because it's all like so crazy. So if there's any review of status, it's every 12 months. A copy of such certification of review shall be filed in the patient's record. If an application for a court order has been made and a hearing is requested, the provisions governing hearing contained in section 931 of this article shall be applicable. If an application for a court order has been made, So B is if an application for a court order has been made and a hearing is requested, the provisions governing the hearing of this article shall be applicable of section 931. C, if an application for a court order has been made, the court, in determining the proceeding, may approve the continued hospitalization of the patient as a voluntary or informal patient. Or if the court finds that the patient is not suitable or willing to continue as a voluntary or informal patient, it may order the discharge of the patient or make such order as it may deem appropriate in the circumstance. And D, prior to the termination of the 12 months from the date of the certification on such first review by the Mental Hygiene Legal Services, or if an application for a court order has been made from the date of the first order and thereafter prior to the termination of the 12 months from any subsequent certification or subsequent order, as the case may be, the director and the Mental Hygiene Legal Service shall conduct another review of the patient's suitability and willingness to remain as a voluntary or informal patient as set forth. Okay, now this is Mental Hygiene Law, Article 929, Involuntary Admission on Medical Certification. Notice of admissions to patients and others. Now this is involuntary. The other stuff that I was talking about earlier was voluntary. Now this is involuntary. Again, here we are, so let's go. Involuntary admissions on medical certification, notice of admissions to patients and others. The director shall cause written notice of a person's involuntary admission on an application supported by medical certification to be given forthwith to the Mental Hygiene Legal Services. B, the director shall cause written notice of the admission of such person, including such person's right under this article, to be given personally or by mail not later than 5 days. Again, the director shall cause written notice on this one. It's also 5 days, excluding Sunday and holidays, after the admission to the following. So notice 5 days, excluding Sunday and holidays, after such admission to the following. 1, the nearest relative of the person alleged to be mentally ill, other than the applicant, if there be any such person known to the director, or 2, as many as 3 additional persons, if designated in writing, receiving such notice by the person so admitted. When the fuck are we ever going to use this? I don't understand. But here it is. We need to know this for some fucking reason that I don't even, there's probably one person in every county who does anything with mental hygiene of these people, and yet we need to know all this crap. Mental Hygiene Law, Article 9.31, Involuntary Admission on Medical Certification, Patient's Right to a Hearing. At any time prior to the expiration of 60 days from the date of involuntary admission, again, at any time prior to the expiration of 60 days from the date of involuntary admission of a patient on an application supported by medical certification, he or any relative or friend or the Mental Hygiene Legal Services gives notice in writing to the director or request for a hearing on the question of need for involuntary care and treatment. A hearing shall be held as herein provided. Oh, this is actually something that makes sense for us. We do hearings at work. Okay. The patient or person requesting a hearing on behalf of the patient may designate the county where the hearing shall be held, which shall be either in the county where the hospital is located, or the county of the patient's residence, or the county in which the hospital to which the patient was first admitted is located. Okay, so that's a little different there. Okay, so the patient or the person requesting a hearing can go to one of 3 places to have this hearing to see if about this involuntary thing, which is different from the last one we did before, where the director wanted a hearing. She had to go to, or an order, she had to go to the Supreme or County Court where the hospital was located. Here, the person or patient requesting a hearing on behalf of the patient may designate the county. This is venue now. For this hearing, the patient, what is this hearing for now? Okay, it just says right to a hearing. I don't even know what it's for. Okay. For a hearing on the question of need for involuntary care and treatment, a hearing shall be held as herein provided. The patient or person requesting a hearing on behalf of the patient may designate 1, the county where the hearing... No. Okay, forget it. The patient or person requesting a hearing on behalf of the patient may designate the county where the hearing shall be held, which shall be either 1, in the county where the hospital is located, 2, the county of the patient's residence, or 3, the county in which the hospital to which the patient was first admitted is located. Such hearing shall be held in the county so designated, subject to application by any interested party, including the director, for a change of venue to any other county because of the convenience of parties or witness or the condition of the patient upon notice to the person required to be served with notice of the patient's initial admission. B, it shall be the duty of the director upon receiving notice of such request for hearing to forward forthwith a copy of such notice with a record of the patient to where the Supreme Court or the county court in the county designated by the applicant, if one be designated, or if no designation be made, then to the Supreme Court or the county court in the county where such hospital is located. A copy of such notice and record shall also be given to the Mental Hygiene Legal Service. C, the court which receives such notice shall fix the date of such hearing at a time not later than 5 days from the date such notice is received by the court, and cause the patient and other person requesting the hearing, the director, the Mental Hygiene Legal Service, and such other person as the court may determine to be advised of such date. So in this article so far, we have a 60 days rules, we have 5-day rules, and I think there was 10 days somewhere. There was 10 days somewhere in here in the beginning. I think that's it. I'm not sure. I'm gonna have to go through this again. Okay. Where am I? Okay. So now what does the court do? Upon such date, the court shall hear testimony and examine the person alleged to be mentally ill, if it is deemed advisable in or out of court. If it be determined that the patient, is in need of retention, the court shall deny the application for the patient's release. Where did we get to release? Okay, I don't know. If the patient is in a psychiatric hospital maintained by a political division of the state or in a general hospital, the court, upon notice to the patient and the Mental Hygiene Legal Service and an opportunity to be heard, may order the patient transferred to the jurisdiction of the Department for Retention in a hospital operated by the state, designated by the commissioner, or to a private facility having an appropriate operating certificate for retention therein for the balance of the period for which the hospital is authorized to retain the patient. I mean, this is like really too much. Okay, let's see what else happens. Okay. Article 9, 9.33, court authorization to retain an involuntary patient. God, we're finally like getting to stuff that the court actually does. Okay. If the director shall determine that a patient admitted upon an application supported by medical certification for whom there is no court order authorizing retention for a specified is in need of retention, and if such patient does not agree to remain in such hospital or as a voluntary patient, the director shall apply to the Supreme Court or the county court in the county where the hospital is located for an order authorizing continued retention. Such application shall be made no later than 60 days from the date of involuntary admission on application supported by medical certification, or 30 days from the date of an order denying an application. Okay, so it's 60 days from the date of involuntary admission, or 30 days on an order denying an application for the patient's release, whichever is later. And the hospital is authorized to retain the patient for such further period during which the hospital is authorized to make such application or during which the application may be pending. The director shall cause written notice of such application to be given to the patient, and a copy shall be given personally or by mail to the persons required by this article to be served with notice of such patient's initial admission and to the mental hygiene legal service. Such notice shall state that a hearing may be requested and that failure to make such a request within 5 days excluding Sunday and holidays from the date that the notice was given to the patient will permit the entry without a hearing of an order authorizing retention. If no request is made for a hearing on behalf of the patient within 5 days excluding Sunday and holidays from the date such notice, this is like so repetitive, so we keep hearing the same thing, of such application was given such patient, and if the mental hygiene legal service has not requested a hearing, the court receiving the application may, if satisfied that the patient requires continued retention for care and treatment or transfer and continued retention, immediately issue an order authorizing continued retention of such patient in such hospital for a period not to exceed 6 months from the date of the order. Continued retention of such patient in such hospital for a period not to exceed 6 months from the date of the order. Or, if such patient is in a psychiatric hospital operated by a political subdivision of the state or in a general hospital, such order may direct the transfer of such patient to the jurisdiction of the department for retention in a hospital operated by the state, blah, 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 or to a private facility having an appropriate operating certificate to be retained herein for a period not to exceed 6 months. Is that 6 months on the other one? Yeah, 6 months. Okay. Retained 6 months, not to exceed 6 months from the date of such order. Upon the demand of the patient or of anyone on his behalf, or upon request of the mental hygiene legal service, the court shall or may, on its own motion, fix a date for the hearing of the application and like answer, blah, blah, blah. The provisions of such section shall apply to the procedure for obtaining and holding a hearing, and to the granting or refusal to grant an order of retention by the courts, except if they've already had a hearing. He shall not have the right to designate initially the county in which the hearing shall be held. If the director of a hospital in which a patient is retained shall determine that the condition of such patient requires his further retention in a hospital, he shall, if such patient does not agree to remain in such hospital as a voluntary patient, apply during the period of retention authorized by the last order of the court to the Supreme Court or the county court in the county where the hospital is located for an order authorizing further continued retention of such patient. The procedures for obtaining an order shall be in accordance with the provision of the foregoing section, blah, 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 provided that the patient or anyone on his behalf or the Mental Hygiene Legal Services may request that the patient be personally before the court, in which case the court shall not grant an order for periods of 1 year or longer unless such patient shall have appeared personally before the court. The period for continued retention pursuant to the first order shall authorize further continued retention of the patient for not more than 1 year from the date of the order. The period for the further continued retention of the patient authorized by any subsequent order shall be for periods not to exceed 2 years each from the date of the order. This makes me want to fucking become mentally ill. Oh my god. Alright, rant over. Back to reality. 935, review of court authorization to retain an involuntary patient. If a person who has been denied release or whose retention, continued retention, or transfer and continued retention has been authorized pursuant to this article, or any relative or friend in his behalf, be dissatisfied with any such order, he may, within 30 days after the making of any such order, obtain a rehearing and a review of the proceedings already had and of such order upon a petition to a justice of the Supreme Court other than the judge or justice presiding over the court making such order. What? They can have another hearing from another judge. Okay. Whatever. Such justice shall cause a jury to be summoned and shall try the question of the mental illness and the need for retention of the patient so authorized to be retained. Any such patient or the person applying on his behalf for such review may waive the trial of the fact by a jury and consent in writing to trial of such fact by the court. No such petition for rehearing and review shall be made by anyone other than the person so authorized to be retained, or the father, mother, husband, wife, or child of such person, unless the petitioner shall have first obtained the leave of the court upon good cause shown. If the verdict of the jury, now it doesn't even say what the jury is, how many people are on the jury, there's nothing here. It just says the jury. So I don't know how many people are on this jury. Do we even care? Who cares? Okay. If the verdict of the jury or the decision of the court when the jury trial has been waived be that such person is not mentally ill or is not in need of retention, the justice shall forthwith discharge him. But if the verdict of the jury or the decision of the court where a jury trial has been waived, whatever, a jury trial or a bench trial, be that such person is mentally ill and in need of retention, the justice shall certify that fact and make an order authorizing continued retention under the original order. Such order shall be presented at the time of authorization of continued retention of such mentally ill person to and filed with the director of the hospital in which the mentally ill person is authorized to be retained, and a copy shall be forwarded to the department by such director and filed in the office thereof. Okay, so this order only needs to be one copy filed with the director of the hospital and shall be forwarded to the department by such director and filed in the office. Okay. Proceedings under the order shall not be stayed pending an appeal. Oh. Proceedings under the order shall not be stayed pending an appeal, except upon an order of a justice of the Supreme Court made upon a notice and after a hearing, with provisions made therein for such temporary care or confinement of the alleged mentally ill person as may be deemed necessary. Okay. Mental Hygiene Law 937, involuntary admission on certificate of a director of a community services or his designee. So now we have these other people coming into play here. The director of a hospital, upon application by a director of community services or an examining physician duly designated by him or her, may receive and care for in such hospital as a patient any person who, in the opinion of the director of community services or the director's designee, has a mental illness for which immediate inpatient care and treatment in a hospital is appropriate and which is likely to result in serious harm to himself or herself or others. The need for immediate hospitalization shall be confirmed by a staff physician of the hospital prior to admission. When are they doing this? Within 72 hours. Now, this one is excluding Sunday and holidays after such admissions if such patient is to be retained for care and treatment beyond such time and he or she does not agree to remain in such hospital as a voluntary patient. The certificate of another examining physician who is a member of the psychiatric staff of the hospital that the patient is in need of involuntary care and treatment shall be filed with the hospital. Why is every sentence like 5 sentences in one? Where am I? Okay, from the time of his or her admission under this section, the retention of such patient for care and treatment shall be subject to the provisions for notice, hearing, review, and judicial approval of continued retention or transfer and continued retention provided by this article for the admission and retention of involuntary patients, provided that, for the purpose of such provisions, the date of admission of the patient shall be deemed to be the date when the patient was first received in the hospital. Really? God. Now let's see what else we got in here. That was that, right? Okay, B. Oops. Oh, I thought it wasn't recording. Yeah, okay. B. The application for admission of a patient pursuant to this section shall be based upon a personal examination by a director. It shall be in writing. Okay. The application for admission shall be based upon personal examination by a director of community service or his designee, shall be in writing, and shall be filed with the director of the hospital at the time of the patient's reception, together with a statement in a form prescribed by the commissioner giving such information as he may deem appropriate. What? I don't know about this stuff. There's just way too much. Okay. If the patient is admitted, the need for hospitalization shall be confirmed by another staff physician within 24 hours. An application pursuant to this subdivision shall be in writing and shall be filed with the director of such hospital at the time of the patient's reception, together with a statement in a form prescribed by the commissioner giving such information as he may deem appropriate, including a statement of the efforts made by the director of community service to locate a designated examining physician prior to making an application. After signing the application, the director of community service or the director's designee shall be authorized and empowered to take into custody, detain, transport, and provide temporary care for any such person upon the written request of such director or the director's designee. It shall be the duty of peace officers or police officers who are members of the state police. Oh, so state police. Oh, or of the sheriff. Oh, state police or the sheriff or peace officer working as a special designees, whatever. Upon the written request of such director, oh God. Upon the written request of such director or the director's designee, it shall be the duty of peace officer, a police officer, as a state police or a sheriff department to take into custody and transport any such person requested and directed by such director or designee. Upon the written request of such director or designee, an ambulance service as defined in subdivision 2, section 3001 of the Public Health Law is authorized to transport any such person. I can't. Oh my gosh. Reasonable expenses incurred by the Director of Community Mental Hygiene Services or his designee for the examination temporary care. I mean, do we really need to know this? I don't know. Oh my gosh. Oh my God. All right, let me just do it. Reasonable expenses incurred by the Director of Community Mental Hygiene Services or his designee for the examination and okay, this is Mental Hygiene Law Article 940. This is the other thing that's always stated. It's 939 and 940 are stated like in the beginning that I read. So okay, emergency observation. Oh, and this for some reason is going to be taken out because I was looking to see that they're changing. It's going to be amended or repealed or something. Where does it say? Oh yeah, this is going to be repealed in July 1st of 2020. This whole thing. So it's going to be out of everything else. So I'm going to do it, but it's going to be repealed. Okay. Emergency observation, care, and treatment and comprehensive psychiatric emergency program. The director of any comprehensive psychiatric emergency program may receive and retain therein for a period not to exceed 72 hours any person alleged to have a mental illness for which immediate observation, care, and treatment in such program is appropriate, and which is likely to result in serious harm to the person or others. The director shall cause to be entered upon the program records, the name of the person or persons, if any, who have brought the person alleged to have a mental illness to the program, and the details of the circumstances leading the person or person to bring the person alleged to have a mental illness to the program. Okay. The director shall cause examination of such persons to be initiated by a staff physician as soon as practicable, and in any event within 6 hours. That is very different. Okay. Examination must be done as soon as practicable within 6 hours after the person is received into the program's emergency room. The person may be retained for observation, care, and treatment, and further examination for up to 24 hours if at the conclusion of such examination, such physician determines that the person may have a mental illness for which immediate observation, care, and treatment in a comprehensive psychiatric emergency program is appropriate, and which is likely to result in serious harm to the person or others. No person shall be involuntarily retained with this section for more than 24 hours. So it can be involuntary retained, but not more than 24 hours. Within that time, the examination by another physician who's a member of the psychiatric staff of the program, and a person is admitted to an extended observation bed. Really? Come on. Okay, the person shall be served the written notice of his status and rights as a patient. The notice shall contain the patient's name. The notice shall be provided to the same person, and in the same manner as the section before, section 939, with written requests for court hearings on the question of need for immediate observation, care, and treatment shall be made, and court hearings shall be scheduled and held in the manner provided in 939. However, if a person is removed or admitted to a hospital pursuant to E or F of this section, the director shall be substituted for the director of the comprehensive psychiatric emergency program. The director of the hospital shall be substituted for the director of the psychiatric emergency program in all legal proceedings regarding the continued retention of that person. Okay. If at any time it's determined that the person is no longer in need of immediate observation, care, and treatment, and is not in need of involuntary care in the hospital, such person shall be released without regard, unless such person agrees to be admitted to another appropriate hospital as a voluntary or informal patient. If at any time within the 72-hour period it's determined that the person continues to require immediate observation, care, and treatment, is likely to continue beyond the 72-hour period, such person shall be removed within a reasonable period of time to an appropriate hospital, and such person shall be evaluated for admission, and if appropriate shall be admitted to such hospital, except that if the person is admitted, the 15-day retention period of subdivision B of 939 of this article shall be calculated from the time such person was initially registered into the emergency room of the psychiatric emergency program. Okay. Any person removed to a hospital without regard of this chapter and shall not be considered to have been transferred or discharged to another hospital. F. Nothing in the section shall preclude the involuntary admission of a person to an appropriate hospital pursuant to the provisions of this article, if at any time during the 72-hour period it is determined that the person is in need of involuntary care and treatment in a hospital, and the person does not agree to be admitted to a hospital as a voluntary or informal patient. Okay, if a person is examined and determined to be mentally ill, the fact that such person suffers from alcohol or substance abuse shall not preclude receipt or retention under this article, under this section. This seems to be a recurring thing. So maybe that's good to just to remember. If a person is examined and determined to be mentally ill, the fact that the person suffers from alcohol or substance abuse shall not preclude the receipt or retention under this article. And all time periods referenced in this section shall be calculated from the time such person is initially registered into the emergency room of the comprehensive psychiatric emergency program. 941 of the mental hygiene law has to do with emergency admissions for immediate observation, care, and treatment, and what the powers of certain peace officers and police officers are. So this might be something that could be on it. Maybe. I don't know. What are the powers of police or police officers as far as this goes? I don't know. So here we go. Any peace officer, when acting pursuant to his or her special duties, or police officer who is a member of the state police or of an authorized police department or force or of a sheriff's department, so that's, state police, the police here, and the sheriff's department, may take into custody any person who appears to be mentally ill and is conducting himself or herself in a manner which is likely to result in serious harm to the person or others. The officer may direct the removal of such person or remove him or her to any hospital specified in subdivision A of section 939 or any comprehensive psychiatric emergency program specified in subdivision A of section 940. Now remember, in 939, the time for them to be able to stay is 15 days, and 940 is 72 hours. Okay. Or pending his or her examination or admission to any such hospital or program, temporarily detain any such person in another safe and comfortable place, in which event such officer shall immediately notify the Director of Community Services, or if there be none, the health officer of the city or county of such action. This has a 15-day rule, and it talks about if the likelihood that they're to stay in a hospital, it's appropriate. If they're likely to harm themselves or others, and the likelihood to result in harm, as used in this article, is substantial risk to himself as manifested of threats or attempts at suicide or serious bodily harm or other conduct demonstrating that he's a danger to himself, or substantial risk of harm to others by homicidal or other violent behavior, which people are placed in reasonable fear of serious physical harm. So the important thing to know here is that they may receive the hospital may receive and retain a patient for a period of 15 days if the person is alleged to have a mental illness which immediate observation, care, and treatment in a hospital is appropriate. Okay. So if they're suicidal, they're allowed to go to, the emergency care, and it would be 15 days that they're able to take them. Okay. The director has to admit the person if they find that if they qualify under the requirements of the section, and they shall not be retained for a period of more than 48 hours unless within such period the finding is confirmed after examination by another physician who shall be a member of the psychiatric staff of the hospital. The person shall be served the written notice, all that stuff with the notice. If at any time after admission the patient, the relative, a friend, or mental hygiene legal services give notice to director in writing, request for a court hearing on the question of need for them to stay there, a hearing shall be held as herein provided as soon as practicable, but in any event not more than 5 days after such a request is received. There is nothing. Okay. It shall be the duty of the director to forward forthwith a copy of the notice with a record of the patient to the Supreme Court or county court in the county where the hospital is located. So these hearings are done where the hospital is located in the Supreme or county court. So that's where the venue is going to be for these types of hearings. Let's see if there is anything. Oh, and then of course at the end of this section, it's all the other sections. It says if a person is examined and determined to be mentally ill, the fact that they also are suffering from alcohol or substance abuse does not preclude the commitment under this section. So, and then, also within 15 days of arrival at the hospital, if a determination is made that the person is not in need of involuntary care and treatment, he shall be discharged unless he agrees to stay. So if he's in need of involuntary care and treatment and does not agree to remain as a voluntary or informal patient, he may be retained beyond such 15-day period only by admission to the hospital or another appropriate hospital pursuant to the provision governing involuntary admission on application support by medical certification and subject to the provisions for the hearing, review, and judicial approval or retention of the transfer. Okay. And now 940 has to do with emergency observation into a psychiatric emergency program. Now, I don't know if anybody knows, Stony Brook Hospital has a psychiatric emergency program. It's called CPEP. So this would apply for there. And I know, they've talked about this because people have said, I can only get them in for 72 hours, for 3 days, whatever. So that's what this is. Okay, the director of any comprehensive psychiatric emergency program, which we can call Stony Brook's CPEP. Yeah. They also have things there for for juveniles, emotionally disturbed kids and stuff like that. So it's just psychiatric, period. But they also have for adults and juveniles, which we're going to see in a little bit. Okay, so the director of any comprehensive psychiatric emergency program may receive and retain a period for not to exceed 72 hours. So again, the other emergency one is 15 days. This one is 72 hours. Any person alleged to have a mental illness for which immediate observation, care, and treatment in a program is appropriate and which is likely to result in serious harm to the person or others. The director shall cause to be entered upon the program records of who brought them there. This is different than the other one because I don't remember seeing this in the other one. I hope I'm not wrong about this, but it says that they'll cause to enter upon the program records the name of the person or persons, if any, who have brought the person there. And I don't remember seeing this in the other one, so I hope I'm right. Okay. This is definitely different, that they have to be seen within 6 hours, but I did a whole video I did this entire section, so I'm not going to really go into it. But just note that there is a difference between an emergency observation, care, and treatment in an emergency room. The other one just says emergency hospital, and this one says comprehensive psychiatric emergency program. So some hospitals do not have a comprehensive psychiatric emergency program, but they might have a psychiatric department, and it's different. Okay, so now we're on 943 of the Mental Hygiene Law, and this is emergency admissions for immediate observation, care, and treatment, and this is a power of the courts. If they would ask anything, I would think that it would be something that happens in the courts or something that a clerk does, but you just never know. So here you go. Whenever any court of inferior or general jurisdiction is informed by verified statement that a person is apparently mentally ill and is conducting himself or herself in a manner which in a person who is not mentally ill would be deemed disorderly conduct, or which is likely to result in serious harm to himself or herself, such court shall issue a warrant directing that such person be brought before it. If, when said person is brought before the court, it appears to the court on the basis of evidence presented to it that such person has or may have mental illness which is likely to result in serious harm to himself or herself or others, the court shall issue a civil order directing his or her removal to any hospital specified in subdivision A of section 939 or any comprehensive psychiatric emergency program specified in 940, willing to receive such person for a determination by the director of such hospital or program whether such person should be retained. Whenever a person before a court in a criminal action appears to have a mental illness which is likely to result in serious harm to himself or herself or others, and the court determines either that the crime has not been committed or that there is not sufficient cause to believe that such person is guilty, the court may issue a civil order as above provided, and in such case, the civil action shall terminate. It does not say it shall dismiss. It says it shall terminate. 945, emergency admissions for immediate observation, care, and treatment. This is the power of the director of the community services. The director of community services or the director's designee shall have the power to direct the removal of any person within his or her jurisdiction to a hospital approved by the commissioner, pursuant to 939 or 940. Okay. If the parent, adult, sibling, spouse, or child of the person, the committee or legal guardian of the person, a licensed psychologist, registered professional nurse, or certified social worker currently responsible for the providing treatment service to the person, a supportive or intensive case manager currently assigned to the person by a case manager program, which program is approved by the Office of Mental Health for the purpose of reporting under the section, a licensed physician, health officer, peace officer, or police officer. If any of those people report to him or her that the person has a mental illness for which immediate care and treatment in a hospital is appropriate and which is likely to result in serious harm to himself or herself or others, it shall be the duty of peace officers, when pursuant to their duty, police officers who are members of the state police or the regular police department or the sheriff's department, to take into custody and transport any such person upon the request of a director of community services or the director's designee, an ambulance service as defined in, some section defined in subdivision 2 of section 3001 of the public health law, is authorized to transport any such person. Any person may then be retained in a hospital pursuant to 939 or 940. Moving on, we have 946, reports of substantial reports of substantial risk or threat of harm by mental health professionals. Okay, so the term mental health professional in this section shall include a physician, psychologist, registered nurse, or licensed clinical social worker. Notwithstanding any other law to the contrary, when a mental health professional currently providing treatment service to a person determines, in the exercise of reasonable professional judgment, that such person is likely to engage in conduct that would result in serious harm to self or others, like this statute is all over the place, he or she shall be required to report as soon as practicable to the Director of Community Services or the Director's designee, who shall report to the Division of Criminal Justice Services, so that's DCJS, whenever he or she agrees that the person is likely to engage in such conduct. Information transmitted to DCJS shall be limited to names and other non-clinical identifying information, which may only be used for determining whether a license issued pursuant to Section 400 of the Penal Law should be suspended or revoked, or for determining whether a person is ineligible for a license pursuant to 400 of the Penal Law, or is no longer permitted under state or federal law to possess a firearm. Oh, so this is like the shootings or something, like the people, Nothing in this section shall be construed to require a mental health professional to take any action which, in the exercise of reasonable professional judgment, would endanger such mental health professional or increase the danger to a potential victim or victims. The decision of a mental health professional to disclose or not to disclose, when made reasonably and in good faith, shall not be the basis for any civil or criminal liability of such mental professional. Oh, so like, if they do or they don't, they're not going to be held responsible? I don't know. I think that's what it's saying. Alright, 947. This is also, there's so much of this that is going to be repealed in 2020 or 2022. It's just a lot in this. It's going to be repealed. But for our purposes, duties of local officers in regard to their mentally ill. All directors of community services, health officers, and social service officials, as defined in the social service law, are charged with the duty of seeing that all mentally ill persons within their respective communities who are in need of care and treatment at a respective community at a hospital are admitted to a hospital pursuant to the provisions of this article. Social services officials and health officers shall notify the Director of Community Services of any such person coming to their attention. Pending the determination of the condition of an alleged mentally ill person, it shall be the duty of the Director or the Community Services Director, and if there be no such Director, of the local health officer to provide for the proper care of such person in a suitable facility. All directors of the community service shall be responsible for. These are the responsibilities of the Director of the Community Services. 1. Receiving reports of persons who may be in need of assistance. Receiving reports of persons who may be in need of assisted outpatient treatment and documenting the receipt date of such reports. Conducting timely investigations of the reports and providing written notice upon the completion of the investigation to the reports. Filing of petitions for assisted outpatient treatment and documenting the petition filing date and the date of the court order. Hey, baby. Coordinating the timely delivery of the court order. Ensuring evaluation of the need for ongoing assisted outpatient treatment. If he or she has been ordered to provide for or arrange for assisted outpatient treatment, then hold on. All right. 947, duties of local officers in regard to their mentally ill. Okay. All directors of community services, health officers, and social service officials, as defined in social services law, whatever, are charged with the duty of seeing that all mentally ill persons within their respective communities who are in need of care and treatment at a hospital are admitted to a hospital pursuant to the provisions of this article. Social services officials and health officers shall notify the Director of Community Services of any such person coming to their attention. Pending the determination of the condition of an alleged mentally ill person, it shall be the duty of the Director of Community Services, and if there be no such director, of the local health officer to provide for the proper care of such person in a suitable facility. B. All directors of community services shall be responsible for 1. Receiving reports of the person who may be in need of assisted outpatient treatment and documenting the receipt date of the report. 2. Conducting timely investigations of the report and providing written notice upon the completion of investigation to reporting the person and program coordinators appointed by the Commissioner of Mental Health pursuant to whatever section that is, and documenting the initiation and completion dates of such investigations and the dispositions. 3. Filing of petitions for assisted outpatient treatment. 4. Coordinating the timely delivery of court-ordered services with program coordinators and documenting the date assisted outpatient begin to receive the services mandated in the court order. 5. Ensuring evaluation of the need for ongoing assisted outpatient treatment. 6. If he is or she has been ordered to provide for or arrange for assisted outpatient treatment. Notifying the Director of Community Services of the new county of residence when he or she has reason to believe that an assisted outpatient has or will change his or her county of residence during the pendency of an assisted outpatient treatment order, and then upon such change of this residence, the Director of the new county of residence shall become the appropriate director. 7. Reporting on a quarterly basis to program coordinators the information collected pursuant to this subdivision. And C. In discharge of the duties disposed by subdivision D of section 960 of this article, directors of community services may provide services directly or may coordinate services with the offices of the department or may contract with any public or private provider to provide services for such programs as may be necessary to carry out the duties imposed pursuant to this subdivision. Right. Duties of directors of assisted outpatient treatment programs. Directors of assisted outpatient treatment programs of this article shall provide a written report to the program coordinators that have to be done within 3 days of the issuance of a court order. The report shall demonstrate the mechanisms are in place to ensure the delivery of services and medications as required by the court order, and shall include but not be limited to the following. 1. A copy of the court order. I'm just doing 2. 2. A copy of the written treatment plan. 3. The identity of the case manager or assertive community treatment team, including the name and contact data of the organization which the case manager or assertive community treatment team member represents, because I'm really going to remember that. 4. The identity of providers of services. 5. The date of which services have commenced or will commence. And that's it. 2. The directors of assisted outpatient treatment programs shall ensure the timely delivery of services described in the first paragraph of 960. Directors of assisted outpatient treatment programs shall immediately commence corrective action upon receiving notice from program coordinators that services are not being provided in a timely manner. Such directors shall inform the program coordinator of such corrective action. B, directors of assisted outpatient treatment programs shall submit quarterly reports to the program coordinators regarding the assisted outpatient treatment program operated or administered by such director. The report shall include the following. Now, this is not the other report that they were talking about. This is a quarterly report. The names of the individuals served by the program. 2, the percentage of petitions for assisted outpatient treatment that are granted by the court. 3, any change in status of assisted outpatients, including but not limited to the number of the individuals who have failed to comply with the court order. 4, a description of material changes in written treatment plans of assisted outpatient. Oh, I'm not even on it. 5, any change in case managers. 6, a description of the categories of services which have been ordered by the court. 7, living arrangements of individuals served by the program, including the number, if any, who are homeless. 8, any other information as required by the Commissioner of Mental Health. And 9, any recommendations to improve the program locally or statewide. C, directors of assisted outpatient treatment programs as provided by 960 shall evaluate the need for ongoing assisted outpatient treatment pursuant to 960 and shall notify the Director of Community Services of the new county of residence when he or she has reason to believe that an assisted outpatient has or will change his or her county of residence during the pendency of an assisted outpatient treatment order. Upon such change of residence, the Director of the new county of residence shall become the appropriate director as such term is defined in 960. Now we're going into a whole section on juvenile delinquents, and this is kind of important to know because we do deal with this in family court. The only thing that I would note that this article does talk about the Division for Youth, and the Division for Youth was replaced now with the Office of Children and Family Services. So you'll see Office of Children and Family Services in juvenile delinquency in family court, and I did look that up, and that took effect October 1st, 2018, where it went from Division for Youth to Office of Children and Family Services. So I don't know if that's something that was part of Raise the Age, but that did change the name, and I think mental hygiene just was not updated, so it has the old wording in here. Let's go on to this. Okay. The Commissioner shall receive and arrange the admission to the appropriate office facility of juvenile delinquents temporarily pursuant to Section 353.4 of the Family Court Act. B. Immediately upon the admission of a juvenile to an office facility pursuant to this section, the Director shall comply with the provisions of Section 907 of this chapter, which that talked about if the person's under 16 or over 16 and less than 18, that whole part. And the mental hygiene legal service shall contact such juvenile and explain and make available the facilities thereof. Any juvenile placed pursuant to this section shall be subject to the provisions of Article 9 of this chapter.